All right, let's dive right into this explainer. Today, we're unraveling a real-life Supreme Court puzzle from the 2010 elections. We're talking massive loopholes, legal intent, and lower courts completely disagreeing with each other. It is a case that perfectly captures how applying the strict literal letter of the law can lead to some incredibly surprising outcomes. To make sense of this whole legal riddle, we're going to break it down into 6 clear parts: the 2010 election complaints, the lower court battles, the premature campaigning loophole, intent and mala prohibita, the doctrine of absorption, and finally, the final verdict. Section 1, the 2010 election complaints, the pregame and game day. So, let's set the scene. It's the 2010 barangay elections, and these candidates suddenly find themselves fighting on 2 completely different fronts. You've got the pre-game stuff, people alleging there were house visits and campaign meetings happening in September and October, which was way before the official campaign period even started. And then you have the game day actions, allegations of actually soliciting votes right inside the Placido del Mundo Elementary School polling place on October 25th. Fast forward a few months to January 2011, and formal complaints are filed, kicking off a massive legal chain reaction. Section 2, the lower court battles, a clash of interpretations. Now, this is where it gets wild. Once prosecutors actually filed the criminal charges, the lower courts looked at the exact same documents and came to completely opposite conclusions. It literally all came down to the word "and." The charging documents accused the candidates of doing X and doing Y. The regional trial court read that and said, okay, this is just one continuous offense of unlawful electioneering. The word "and" is just connecting the actions. But then the Court of Appeals steps in, and they're like, no way. By using the word "and," you are charging them with multiple distinct offenses all rolled into one single document. In the legal world, they call this duplicity, and it's a huge deal because it violates a defendant's right to know exactly what single crime they're actually defending against. So the Court of Appeals quashed, basically voided, the charges. And this massive clash, that is exactly what catapulted this case all the way up to the Supreme Court. Moving on to Section 3, the premature campaigning loophole. Can you break a rule before the game begins? On the surface, the law here feels pretty cut and dry. Section 80 of the Omnibus Election Code basically says you cannot jump the gun. You're not allowed to engage in partisan political activity or solicit votes before the official campaign clock actually starts ticking. Sounds like an open and shut case against those early September and October house visits, right? Well, not exactly. The Supreme Court threw an absolute curveball here. They asked a question that literally flips this entire charge on its head. Can you actually break a campaign law before you are officially recognized as a candidate? Let's break down the 3 steps you need to actually prove the crime of premature campaigning. Step 1, a person engages in partisan activity. Step 2, that act is designed to promote a specific candidate. And Step 3, it happens outside the official campaign period. But looking closely at these steps, the Supreme Court realized that Step 2 hides a gigantic, legally binding loophole based purely on how our election laws are currently written. Here's the catch. According to the court's strict interpretation of current Philippine law, specifically Republic Act 9369, even if you file your certificate of candidacy super early, you are not legally considered a candidate until the exact second the campaign period starts. Basically, any political moves you make before that date, you're just doing them as a regular citizen, not a candidate. So this creates the ultimate loophole. The Supreme Court had zero choice here. They had to rule that because you are not legally a candidate until the campaign period kicks off, it is essentially impossible to commit the crime of premature campaigning. Now, I know that sounds totally counterintuitive, but the court was just impartially applying the clear language of the law. They basically said, hey, it's up to the legislature, not us judges, to fix the wording if they want to penalize this early campaigning. The result? All those pregame charges were completely thrown out. Section 4, intent in mala prohibita, the game day violations. Okay, so the early campaigning charges are gone. But what about the game day stuff? What about soliciting votes inside the actual polling place? To solve this second puzzle, the Supreme Court relied on a core concept in criminal law, known as mala prohibita, which literally translates to wrong because it is prohibited. To wrap our heads around this, let's contrast it with mala in se. Mala in se covers crimes that are inherently evil. Think theft or murder. For those, the malicious intent of the offender is absolutely crucial to get a conviction. But election laws, they fall under mala prohibita. These are acts penalized by statute just to maintain public policy, like keeping polling places safe and orderly. And here's the kicker. For mala prohibita crimes, your criminal intent doesn't matter at all. The court does not care why you did it. Simply stepping over that line consciously and freely is enough to break the law. Which brings us to Section 5, the doctrine of absorption, solving the multiple charge puzzle. Now we have to figure out, did these folks commit one crime on Election Day or several? See, the prosecutors hit them with two rules at the exact same time. First, Section 261, unlawful campaign, that's soliciting votes inside the polling place. And second, Section 192, unauthorized presence, which is just stepping foot inside a polling place when you're not legally supposed to be there. And remember, because these are mala prohibita crimes, just physically being in the room is enough to get you in trouble. But charging them with both of these at once brings us to another really fascinating legal tool used by the court. Instead of just piling on duplicate charges, the court applied the doctrine of absorption. This is a legal principle where, if one crime is inherently part of another, like you literally have to commit crime A to commit crime B, it's not treated as a separate offense. The bigger primary crime simply swallows up or absorbs the lesser one. And this principle completely solves the puzzle. Think about it. The primary goal of the accused on Election Day was to solicit votes inside the school. But to do that, they physically had to walk into the polling place, right? So their unauthorized presence was a necessary, unavoidable step to unlawfully campaign. You can't illegally campaign inside a room without, actually being inside the room. Because of that, the lesser offense of unauthorized presence gets totally absorbed by the bigger unlawful campaign charge, so they only committed one single crime. It turns out that First Regional Trial Court was actually spot on all along. It wasn't duplicity, it was just a single absorbed offense. And that leads us to Section 6, the final verdict, the Supreme Court's resolution. So let's look at how all these pieces come together for the final resolution. The Supreme Court carefully and very strictly applied the exact letter of the law here. For the premature campaigning charges, completely quashed and dismissed for everyone. Because of how the law defines a candidate, committing that crime was technically impossible. However, the Election Day offense inside the polling place was upheld. By using that doctrine of absorption, the court confirmed it was a single, totally valid charge. So the case was remanded, meaning it was sent right back to the trial court. So the accused could finally face trial for that one specific Election Day violation. This whole legal journey leaves us with a pretty massive, lingering question about the real-world wisdom of our election codes. I mean, if the law, exactly as it's written by lawmakers today, makes the very concept of premature campaigning legally impossible to commit, is it time for our legislature to finally step up and rewrite the rules of the game? It's a huge question, and it's the perfect thought to leave you with as we wrap up this explainer. Thanks so much for diving into this with us, and we'll catch you next time.